Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in San Diego, and I'm joined today, as always, with Miki Matrician, who's the co-managing partner of our Boston office. How are you doing today, Miki?
Good, Kim. Hi.
All right, well, today we are going to discuss the current situation with the visa revocations and SEVIS terminations for F-1 students and recent graduates. So at the end of March, the U.S. Department of State began to revoke the F-1 visa stamps of some students and recent graduates of U.S. universities and colleges. We then started to see the SEVIS terminations of these individuals as well. So for those who are unfamiliar, SEVIS, which is the Student and Exchange Visitor Information System, is the database where F-1 student statuses are tracked and maintained, typically by the designated student officer at the university. But Immigration and Customs Enforcement is the agency that houses this SEVIS database. So normally, as I mentioned, it would be the DSO who have the authority to make updates to the F-1 SEVIS records. The termination of status, which ends an individual's permission to stay in the United States, can occur when SEVIS is terminated. There's a notation in SEVIS. So the F-1 status may be terminated if an individual with such status fails to maintain their status, or if an agency terminates their status. So typically, the student's failure to maintain F-1 status was reported by the colleges and universities themselves. If, for example, the international student engaged in unauthorized employment or failed to maintain a full course of study or was convicted of certain crimes. So the agency-initiated termination of status is limited by statute. So we don't typically see termination of status via SEVIS done directly by ICE. But in March, ICE did begin to terminate F-1 student SEVIS records. And the SEVIS terminations also terminated their curricular practical training, their optional practical training, and the STEM OPT extensions as well, if those individuals were part of those programs. So that's a long way of saying there's a lot going on with F-1 students and with the SEVIS issues. Miki, can you explain to us what has been happening and why many of these students have had their SEVIS terminated?
Yeah, during the last few weeks, the U.S. government has essentially changed its regular practice related to visa revocations and status terminations. And, as you said, the government has been terminating individuals' F-1 student status, either in addition to or, instead of revoking their F-1 visa stamps. And so what that means is that the F-1 students whose status has been terminated no longer have permission to remain in the U.S., even if they have a valid F-1 visa stamp, which is the document to enter into the United States. And so the understanding for the SEVIS terminations, based on discussions with many of these F-1 non-immigrants, is that SEVIS terminations are based on certain actions and, in some cases, for no reason. Some of the individuals had been involved in situations in which they have been arrested, convicted, or even a victim of a crime. And for many, these were prior criminal records that were subsequently vetted by U.S. consulates prior to the F-1 student visa being issued. In other situations, the individuals had minor traffic incidents or infractions or domestic arguments even between themselves and significant others where well-meaning neighbor might have called the police. None of these would normally render someone inadmissible under the immigration laws, but in some of these cases, based on their encounter with law enforcement, ICE terminated the student statuses without any sort of due process. There also appears to be situations in which individuals were involved in protests or even social media postings related to the Middle East conflict, where the U.S. government stated the conduct was anti-Semitic.
So then how were the F-1 non-immigrants notified of their visa revocations or the SEVIS termination?
Yeah, some individuals received an email from U.S. Department of State saying that their F-1 visa had been revoked. And in other situations, the F-1 non-immigrants got an email notification from their designated school official saying that their SEVIS records have been terminated. And because of that, CPT, OPT, or STEM OPT extensions have been terminated. And these emails often don't provide a specific reason for the termination. The ones that I have heard about say that they failed to maintain status and or that they were identified in criminal records records check and that their visa was revoked. And there's no other specific information that's provided. And so often the F1 students are left kind of confused as to what triggered this action. And so, when that happens, their work authorization is terminated immediately, which impacts our global mobility professionals, right? And to make it even more confusing, there have been reports that ICE has argued that SEVIS terminations don't terminate F1 status and that it doesn't terminate work authorization. So that added more confusion and chaos, I think, to everybody's situations. So, I would say council should be contacted if there was a situation like the ones that I just described related to F1 visa revocations and SEVIS terminations.
Yeah, it's right, Miki. There's been a lot of confusion and ways that things are treated differently in different circumstances for these individuals. And you mentioned that, with a SEVIS termination, it could terminate the CPT, OPT, or STEM OPT. So were the employers of which you were aware, were they notified of the work authorization terminations for these individuals?
No, the employers were not directly notified of such work authorization terminations by the US government. They were only really notified of the work authorization termination by the F1 visa holders themselves. And if employer was notified that the work authorization was terminated, they would be required to stop employing the individuals, as it could be determined by ICE to be knowingly continuing to employ an individual that does not have work authorization.
Right. And that's where, we're letting HR individuals and global mobility professionals know that, an employer might not, in this circumstance, are not going to get direct notification from the government, or at least what we've seen, they've not received the direct notification from the government of termination of work authorization. So they really are, in a situation where they don't necessarily need to do anything unless they're notified directly by the student. So it's put employers in a bit of a bind as well, because it's termination of employment authorization that is immediate, right, until some further action is taken. Which brings me to the next question that I have to ask you, Miki, was as the numbers of SEVIS terminations became known, right, we saw a snowball effect over the course of a little over a week, and more F1 individuals started reaching out for assistance, counsel. Some individuals departed the U.S. immediately. And Miki, can you tell us a little bit more about what we saw happen last week as things really got to snowball in this situation?
Yeah, basically, there have been a lot of lawsuits filed to request temporary restraining orders, TROs, as well as injunctions. And basically, the ask is for the courts to issue an order to stop ICE from terminating the F1 status and to prevent them from putting these F1 visa holders in proceedings. And so, in many instances, these courts have been granting the TROs and injunctions. And based upon a determination that these F1 visa holders have demonstrated a likelihood of success on the merits of their claims and that they would face immediate and irreparable harm without this judicial intervention. And so, basically, the irreparable harm, the argument is that the irreparable harm is deportation and the inability to complete studies and about leaving their employment. In many situations, too, the courts have ordered that SEVIS be reinstated, which means that the individual can return to classes, or if they've already graduated, that they may continue with their employment pursuant to the OPT or STEM OPT extensions. There's still more happening at this time as more and more people are bringing lawsuits and pushing back against ICE, and they're arguing lack of due process given the government's way of going about this. We've also heard of reinstatements of F1 status by the government agency without any negotiations. So a lot has been happening, and the situation is really fluid. But on a different note, there's been another update on the Venezuela TPS that we've been watching closely. Can you tell us what we should know about the current situation for Venezuela TPS?
Yeah. So, what we've been looking at for employers is, that whether or not that Venezuelan TPS work authorization is terminating. And at the end of last week, the U.S. Court of Appeals for the Ninth Circuit did uphold the lower court's decision. And for now, they preserved TPS for about 350,000 Venezuelans. So those Venezuelans were, set to lose their work authorization on April 3rd, and they would lose their deportation protections on April 7th. So we had, a stay of, the termination that was right on March 31st, and then USCIS provided guidance on April 2nd, and now the court has upheld that. So that's a bit of relief for our HR professionals, global mobility professionals, as well as the foreign nationals who are relying on the ability to remain in the U.S. and continue to work. So that was good news at the end of the week. And also, as you explained, Miki, and the good news with the students, many of them winning their court battle, so to speak. So we'll see how that continues. So I think that's a wrap for today's session. Stay tuned for future episodes on updates to the immigration landscape, which, as Miki mentioned, is very fluid right now. If you don't already, please follow us on our LinkedIn page for WR Immigration, as well as our individual profiles. And we also transcribe each and every Rapid Fire Wednesday episode and post it to a weekly newsletter that you can subscribe to. And the link to subscribe will be in the video description. So until then, we'll see you next week, Miki.
Thanks, Kim. Good to see you.